Hello, welcome to Illinois Law with legal news that you can use, sponsored by the Illinois State Bar Association. My name is Sam Kavathis and I'll be your host for tonight's show. Our topic tonight is medical malpractice, and I have three fine guests to help us with our discussion. My first guest is Judge Elizabeth Budzinski. She is assigned to the jury trial call in the Law Division of the Circuit Court of Cook County. Prior to her current assignment, she was assigned to the motion call of the Law Division. Before her selection as an associate judge, she was a partner at the law firm of Wilson, Elsner, Moskowitz, Edelman, and Dicker, and she handled litigation matters and medical malpractice. Judge Budzinski is a past president of the Women's Bar Association. Judge, welcome to tonight's show.
Thank you. I'm glad to be here.
Thank you. Our second guest is Ron Kalish. Ron is a trial lawyer since 1992, and he is a partner with the firm of Steinberg, Goodman, Kalish, where his practice is limited to personal injury, medical malpractice, and product liability. Ron has tried numerous cases over the years in medical malpractice, nursing home neglect, motor vehicle, premises, and other types of civil litigation. He has also argued cases before the Illinois Appellate Court and the Illinois Court of Claims. Ron has also lectured other attorneys in the area of tort law for continuing legal education. He also volunteers his time teaching constitutional law to elementary students in the Chicago public school system through an outreach program called Lawyers in the Classroom, coordinated by the Constitutional Right Foundation. Ron, welcome to tonight's show.
Thank you, Sam.
And our third guest is Karen Enright. She is the founding partner of Winters Enright Salzetta O'Brien, LLC. She concentrates in complex medical malpractice and personal injury cases. Karen is a past president of the Women's Bar Association and an active member of the Illinois State Bar Association, as all our panelists are members of different committees for the Illinois State Bar Association. Karen, welcome to tonight's program.
Thank you, Sam.
Well, why don't we start out with medical malpractice. First of all, tell our listeners, how do you know if you have a medical malpractice case? Where do they start?
Most clients call and they want to know, that's the first question that they ask, whether or not they have a medical malpractice case. And we often tell them that we need to get full copies of their medical records. It's not something that we can normally determine over the phone. If you have an auto accident or if you have a slip and fall, that might be something we can discuss over the phone. But medical malpractice is a unique type of case. So in order to have a full review, you need all of the medical records, any films that you might have, so you can get a comprehensive idea of whether or not you have a case.
And how do you go about getting medical records? Does a client get the medical records? Who gets the medical records?
That's a good question. All hospitals are very well versed in turning over medical records. They usually have departments whose job
Do they have to do that? You know, people probably ask, you know, how can I get my records? Can I get them?
Everybody is entitled to their records. They'll have you sign an authorization, and once the authorization is signed, they have an obligation to turn over those records to you. Sometimes there is a charge, and they usually charge a copying charge. And I always tell clients that call, it's best to first call the facility first, let them know you want to come in, because if you just show up, chances are those records won't be ready for you, and then you'll have to make a second
Are there some cases you can, you know, when you first hear about it, can you at least tell them right away that it's probably not a case without even getting the records? Are there some calls that come in like that?
There are a number of calls that you can field. And back to your prior question, there is a Illinois Medical Studies Act that requires hospitals and doctors to turn over your records.
Can they charge you anything they want to for the records?
There's a statutory fee for the records and what they can charge. There's a limited amount on what they can charge, but they do charge per page. Back to your second question, though, in Illinois it's very difficult to prove a medical malpractice case if there aren't a certain amount of damages. So some cases, unless there's some type of permanent injury, you most likely won't have a doctor sign an affidavit saying that there is a case unless there's some type of permanency.
And when the records come in, what happens to those records then?
Well, usually I'll have the client come in, make an appointment to see us with the records, and I'll go through a detailed interview with the client along with the medical records to find out exactly what their perspective is as to what went wrong. And that's usually where I start, is where do you think something went wrong, and why do you think they did something wrong? And from there we just go through the records, and ultimately before a lawsuit can be filed in Illinois, a medical negligence case, those records have to be reviewed by a medical doctor or any doctor in the same area that's at issue in the case They have to sign an affidavit that says that they've looked at those records and that they believe that there is a meritorious or reasonable basis for filing a lawsuit.
Before we get into that aspect of it, you, the attorney, then can't just say, oh, you've got a case, we're going to file a lawsuit?
No, the law in Illinois requires that there is an affidavit that is signed by a physician who practices in the same or similar type of medicine as the person that you're trying to say committed the malpractice. So you can't necessarily have an orthopedic surgeon sign an affidavit saying that an anesthesiologist did something wrong. Normally when we get the cases, we go through and we do a timeline of what happened, because sometimes what the client thinks went wrong is not exactly the type of malpractice that actually occurred. So then you have the case looked at by a consultant who specializes in that area of malpractice. And usually, if it is a case, that same doctor or consultant is with you from the beginning of the case until the end of the case. And when you file the case, the attorney also has to sign an affidavit saying that they consulted with a physician that specializes in that area.
Now, in other cases, you don't need that. This is just strictly special for medical malpractice cases. It's needed there.
And the reason for the law, and it's a good law, it's to make sure that there aren't frivolous types of claims that are brought, because making an allegation against a doctor or a hospital or a nurse or any healthcare provider is a serious allegation. And so the law really is there to make sure that those cases that do get in through the courthouse steps have some merit. And really, we do the same thing as lawyers. The truth is, in these cases, we want to make sure that we're getting involved in a case that has a good chance of winning, because, frankly, that's how plaintiffs' lawyers that do this kind of work get paid.
Judge, you usually see that when medical malpractice cases are filed, usually most of those cases are legitimate cases that go along for a while in the case, versus maybe some other type of case where there can be some motions to get rid of the case early on.
Yes. The medical malpractice cases that are filed are cases that aren't dismissed at what we call the motion stage or the pleading stage, that they don't state a cause of action or they really have no legal basis. The doctor's affidavit really provides a basis of that the doctors have allegedly done something wrong.
Right. So it takes that away from the other getting rid of the case early on through the motion practice we talk about later on in the show. All right, let's talk about now getting an attorney now. Now with the internet, you can go type in medical malpractice attorneys and a bunch of names pop up there. How do you know who you should go to? I mean, what's a good way for a person to say, how am I going to get a malpractice attorney? It sounds like it's more complicated than a lot of other cases.
There is a process either through the internet or through friends and family members. But in medical malpractice, it's a very specialized area. And you want to make sure that you have an attorney that has practiced in the area of medical malpractice, that has been successful in the area of malpractice. And most times, attorneys on their website list cases that they've had that they've been successful in. And you can do searches on those attorneys to see whether or not they have practiced in that area. In addition, you want to make sure that you use an attorney that has access to these experts. A lot of times when you sue a doctor in the state of Illinois, other doctors won't sign that affidavit. You have to go outside the state, and you have to be willing to finance that, because generally we don't take a fee until we win at the end of the case. So all of our costs are up front, and you have to find an attorney who's willing to take those costs.
Who pays for those costs? I mean, what is the cost involved in a malpractice case?
Well, we advance the costs typically, but at the end of the case, win, lose, or draw, it's the client's responsibility. But cases can cost tens of thousands of dollars very easily from the time you take it to get through trial.
Are there questions maybe a client can ask a lawyer about? Any questions specifically maybe?
Yeah, Karen touched on it. I think very important that when you get on the phone with the lawyer, you ask him or her directly, have you tried these cases? It's one thing to have the case and to work it up, but lawyers who have actually tried these cases to verdict, it's a very good question. And ask how many have they tried. Ask them for the names of the cases that they've tried. Ask them if perhaps they have clients that are willing to talk to them about experiences they've had with that lawyer. I've had clients ask me that, and frankly, I'm thrilled to share it with them. I think it's great information that a prospective client can ask a lawyer.
And a client would want to know from the get-go whether or not they have a conflict with that doctor. Oftentimes, we have doctors that testify in our cases that are non-medical malpractice cases. And in those types of cases, you can't sue that doctor. So when you call an attorney, tell them the name of the hospital and the name of the doctor to make sure that lawyer doesn't have a conflict.
Now, once you've gone through the process of having the case reviewed and the doctor says that there's negligence involved, does that necessarily mean that a client has a case just because there's negligence that you're going to file a malpractice suit on? And what's the criteria that you need? Because you just said to me that you know, there's a lot of expenses involved in cases because people come in and say, well, there's negligence and there may be negligence and they can't get a suit filed.
Yeah, legally, a lawsuit can be filed if there's negligence, but the reality of it is, if the case doesn't have a substantial enough injury, the risk that plaintiff's lawyers have in taking that case is that you're going to have to spend hours and hours and hours of time, hundreds of hours of time, tens of thousands of dollars, and if there isn't a substantial injury, any verdict or settlement that might come from that might not even exceed the costs.
So the client may end up with nothing, so you're
and
spending a lot of time with the cases.
Yeah, a lot of times there is clear-cut negligence, but you know, I say no harm, no foul.
Right.
You know, people are okay, and frankly, that's the better outcome for these folks.
And do you find that in your practice a lot, that just because there's negligence, you tell the clients, and does that happen a lot, where no lawsuits filed because the clients either made a recovery or the damages aren't substantial enough?
And I'll find that clients would rather hear from the get-go whether or not, A, there was malpractice, and B, there are enough damages. And if you're honest with them from the beginning and tell them that although there might have been malpractice, sometimes they're relieved to know that either the doctors did everything they could and that you're not just filing a case because they want you to. And other times they're relieved to know that they don't necessarily have a case, because it's anguish on the clients as well for them to have to, you know, relive some of the medical malpractice. So when you're upfront with them and explain to them the process that you need a required amount of malpractice and a combined amount of damages, I find often, you know, when you're honest with them up front, that it really makes for a better client relationship.
We're here with the Illinois State Bar Association. Our show is Medical Malpractice, and my guests are Judge Elizabeth Buzinski, Ron Kalish, and Karen Enright, and we'll be back in just a few minutes after these public service announcements.